messes up. So thanks everyone. Thanks everyone for coming today. I did leave about, I think, 15 minutes for questions at the end. I don't mind questions being asked throughout the presentation to the extent that it would help clarify the topic that I'm discussing. So I'll kind of jump into it. I apologize in advance. The presentation might not be the most cohesive one because I could legitimately spend hours and hours talking about this topic, and there is so much to cover. So I've tried to narrow down as much as I can, but for the purposes of today, I really wanted to focus on children in need of care and the juvenile justice system. So essentially, we're talking about children with court oversight, oftentimes in the foster care system, and how that impacts their relationship with the juvenile justice system if and when they do enter it. So this is a very rudimentary overview of our SINC process in Kansas. So SINC is essentially what it means is a child in need of care case. Like I said, oftentimes, I would say most people, when they think of a SINC case, they might not know the word, but they're oftentimes thinking of children who are in foster care. That, of course, does not cover every single child in need of care case, but that just gives some of our audience a good understanding of where we're starting. So we'll talk about briefly the child in need of care process first. So this is a specific kind of court case. And the process essentially begins as a child, for some reason or another, is identified as being either abused, neglected, they lack any kind of parental control or authority. Sometimes it can be as simple as not attending school, or oftentimes we see older children enter the system because they've run away from home. When we're talking about the child in need of care process, once a child is identified, and the identifying agency is ultimately going to be the Department of Children and Families. Of course, lots of social workers can be involved with lots of other agencies, but the Department of Children and Families, DCF, is the main provider, overseer of foster care and the child in need of care system. So if DCF, for example, refers a case to the local district attorney's office, and the district attorney believes that based on the information they have, there is enough to file a SINC case, then they choose to do so and they file what's called a petition. After a petition is filed, we eventually get to something called adjudication. That is one of the first times that in many cases that the family, the child, and the parents are in front of the court, and the court actually makes a decision based on what the prosecutor filed and based on the evidence available or what's presented. Will this case continue as a child in need of care SINC case moving forward? So that's kind of our measure of is there enough, and it's part of our checks and balances system. So the court determines if legally that child is a child in need of care, and if not, then they release that child from SINC custody, and basically there's no court oversight. From there, as we're basically doing a SINC case, and this can be, a years-long process. It can be a relatively short process, but we talk a lot about permanency and case plans in child in need of care cases. So there are a variety of things that the court can do at certain points in a SINC case. So when a child is identified as a child in need of care, it could be as simple as the court realizes that there is, let's say, a grandparent who is ready, willing, and able to take care of the child, and perhaps the court can order placement of that child with the grandparent, and then they can effectively close that sink case. Child is out of the system. Or, of course, what we commonly see is reintegration of children into their home, so with their parents. And of course, there is always the option of moving forward with a termination of parental rights, which gets us to something like adoption or another alternative. Then the goal of a child in need of care case is always to achieve permanency. So permanency can look like a variety of different things, but permanency could look like reintegration. Ultimately, it could look like an adoption. It could be an official guardianship through the sink case or conservatorship, or a common term that we use in the system is called aging out. So that is when a child is not going to be adopted or reintegrate by the time they turn 18. So they are in DCF custody, potentially in foster care when they become an adult. So this is just kind of an overview of permanency options. So that is, again, what is going to happen to this child. And permanency options can vary throughout the case. So in this first branch here, we have what we call like a DCF court oversight case. So this would be an example of children are not removed from their home, but the court recognizes that this family needs services. So there is a court case and there are hearings, but the child is still living with their parent. Kind of on a related note to that, which I mentioned in the last slide, direct placement with a family member or an NR-kin placement, that stands for non-related kinship placement. So like a very good family friend who was willing to take care of this child, but is maybe not biologically related. And those, of course, involve the child never entering the foster care system, ideally. The second branch is how I view it when the child is out of home. So of course we can have the child out of home with the goal of reintegration, or we can also have a child placed out of home without the possibility of reintegration. So that could look like one of those age out situations where the child just reasonably, there's not enough time for the child to be adopted or to reintegrate home before they turn 18. Or it can look like parental rights are terminated and then we have an adoption. These are some generic child in need of care statistics from Kansas. I, of course, will not read these word for word to you guys, but these were just some numbers that I found that were particularly interesting, especially this bottom one. So as of October 31st, 2024, we were looking at 5,762 Kansas children in out-of-home placement. So that number doesn't even cover the amount of children who are in a sink case or with DCF oversight. That is just talking about out-of-home placement. Now we're going to kind of do a shift over from the child in need of care process, but keep that in mind. We're going to shift over to the juvenile offender process. Again, this is very, very simplified, just for the purposes of starting this discussion. So I think of the juvenile offender process in 5 main steps. There are, of course, lots of details under these and lots of different things that could happen, but this is just your basics. So the first thing that happens in any juvenile offender case, and I should clarify, juvenile offender for us non-lawyers is essentially just saying a child criminal case. So an investigation would be the first step. So a minor child is investigated for violating the law and or accused of violating the law. During that investigation process, that's where our children are facing a lot of police contact, possibly a police interrogation. That's when they may have the opportunity to make their own statement, write a narrative, that kind of thing. Then we get to that second step of charging. So after there's an investigation, if a child is, if the police believe that a child has broken the law and they have adequate evidence to move forward, then the police officer or the police department forwards the case file of their investigation to the prosecutor. The prosecutor then decides, is there enough here legally for me to file criminal charges? If the prosecutor decides to file those charges, they do so by filing a formal complaint. So then we get into more of the weeds. Now, this very much varies on the type of case that we have. So when we talk about juvenile detention and detention hearings, this does not apply to every single juvenile that has a criminal case filed against them. Typically, when a juvenile is arrested and detained, it's for more serious crimes like a felony. So oftentimes for things like theft, maybe traffic violations, for kids that have no other contact with the criminal justice system previously, they might be, given a ticket, they might be investigated, and then later served with a complaint, and they have to go to court. For some of our more serial offenders, or for more violent or more serious felonies, oftentimes after that complaint is filed, then the police department is ordered by the court to go take this child into custody. So then we're at that juvenile detention hearing stage. And after that child is taken into custody and charged with a crime, then in the state of Kansas, a hearing has to be held within 72 hours to determine if the child will stay in detention or if they'll be released. So you can kind of think of this almost as a bail issue, a bail hearing. And that's when the court makes that determination to release the child or not. And then we get on to the next stage. So adjudication, for some reason or another, the juvenile justice system decided to use the word adjudication, which is essentially a fancy way of saying guilty or not guilty. So we just use that word. Adjudication eventually results in, is this child found guilty of a crime, or do they plead guilty? Do they request a trial? Are they found not guilty? So lots of things go into that process. Once we have an adjudication, so of course, this is assuming that a child is found guilty of a crime. Once we have that, then we get to the sentencing part. So sentencing involves the court deciding, based on the crime, based on a variety of factors, what are we going to do to hold this child accountable? This slide reflects a variety of different sentencing options in Kansas. These, of course, range from the very mild, I would say. So that could include something like mental health services. So if a child is acting criminally and it's tied to mental health issues, part of their sentence might be to engage with mental health professionals. We also have things like probation. A lot of people will be familiar with that probation bubble. And the most serious, I would say, in this section is Worst case scenario, the juvenile is sent to the Kansas Juvenile Correctional Complex for sentencing, and that is unfortunately kind of what you can think of as kid jail here in Topeka. That's where we have our state juvenile correctional complex. So that's kind of the introductory material that I wanted to get out of the way without complicating things too much. And now I'm going to narrow in on, I want everyone to think about that SYNC case process and then the juvenile process. So these are two different kinds of cases. Remember that SYNC case involves children who need help, children who may be in foster care, removed from their parents, or are involved with DCF. That juvenile justice system, of course, we have many juvenile offenders and juvenile cases, juvenile crimes that do not involve the SYNC system, but oftentimes they do unfortunately overlap. So that's what I'll be focusing on today, is children involved in both kinds of cases at the same time. This is going to be a little bit squishing in terms of topics because there's a lot of overlap. So when I was doing my research and putting this presentation together, I identified kind of 4 categories that I wanted to highlight and cover. So 4 categories that show how children in the system, so SYNC kids, are disadvantaged compared to those who are not in foster care or in the system. And that's in terms of a juvenile offender case. So again, this is pretty squishy and they overlap a lot, but a lot of the things that we see in children in need of care who have juvenile cases, they are facing an uphill battle many of the time compared to other youth. So we have, of course, with children in need of care, they might lack that parental figure. And when I say parent throughout this presentation, that can be used simultaneously with like guardian. So of course, not all children are raised by biological parents. That could look like the aunt who's been acting as the parent, the stepfather, all kinds of things. So that is kind of a risk factor for our kids in SYNC custody when they end up in the juvenile offender system. Lack of stable housing is another factor that we often see disadvantaging SYNC youth. Same with financial resources or lack thereof. And number 4 is more of a anecdotal thing that I'll talk about later, but SYNC children have increased agency oversight. So DCF oversight, social workers paying attention to them, which can naturally cause some more issues and challenges if they are facing criminal charges. I'll also just kind of make a disclaimer. Of course, most of these things that we're going to be talking about, these 4 factors, these can easily apply to children who are not in need of care. So children who are at home with their families, but we're just going to talk about it for the purposes of SYNC children. So just wanted to make that plug that, of course, we recognize that poverty resources can affect more than just children in need of care. Okay, so our first factor that I wanted to discuss with everyone is, by nature, for the most part, children in need of care lack a parental figure, a strong parental figure, or maybe none at all, and a lot of them lack a stable family or guardian. So what we often see in SYNC cases is children don't have a strong parent advocate. And of course, when we're talking about children in need of care, this parens patriae Latin term, that is just a fancy way of saying for SYNC children, the state acts as their parent. So when the state takes custody of kids, they act as that parent. But as you can probably imagine, in many ways, the state acting as your parent is no substitution for a parent or guardian who loves you, cares for you, and has your best interests in mind. So here's our little 5-step process, again, in the juvenile justice system, just to remind ourselves. So I want to talk about the different steps of the juvenile process, the juvenile offender process, and how the lack of a parental figure can really impact SANK children in disproportionate ways. So when we're talking about this investigation stage, it seems like common sense, but I think oftentimes we don't think about it. Investigation could look like, in a criminal case, the police show up at your house and they say, hey, we want to talk to, we want to talk to 15-year-old Bobby. We think he stole a car. If a child has parents who are watching out for them and looking out for their best interests, they have a different motivation to protect their own children. So of course, parents can step in and say, hey, no, you cannot talk to my child, or you can talk to my child, but only if I'm there, or hey, we're going to hire a lawyer. Of course, children in need of care might not have that parental role model, that figure to step in. And that, of course, leads to youth doing things like incriminating themselves during police interrogations. It leads to them perhaps being pressured by police, making false confessions, and it really minimizes their chances of beating this charge or getting a favorable deal, or for that matter, being found not guilty when the time comes. Then we also look at detention and sentencing. So when we're making decisions about, and I say when we're making decisions, but when juveniles are making decisions about what to do ultimately with their case, parents, of course, are or can be a big help. So at the detention stage, generally parents want their child to be returned to the family home. SANK children might not have that same benefit. So just to give kind of a real life example, when I, as a juvenile defense attorney, show up for a detention hearing, one of my first questions is, does my client have parents that are willing to take them back into the home, provide supervision, guidance, etc.? Obviously, for a lot of SANK children, they do not have that. And unfortunately, if they do not have a stable family to go back to, it is significantly less likely that they'll get out of detention in a reasonable time. Then, of course, at sentencing, parents generally, this of course does not apply all the time, but parents generally don't want their children spending time in a kid prison. And so they will advocate at sentencing, let the court know that they'll cooperate in any way. And again, if a child in need of care is in foster care, lacks that parental figure who is looking out for them, then they could have disparities in sentencing. Then oftentimes what I find, now parents can be helpful and harmful in this arena, but adjudication, when we're talking about what do we do do a plea deal? Do we set a trial? What kind of trial do we have? Parents can often assist their children in understanding this process. A lot of the kids that we see, they have no idea what a judge is, what a trial is, what a jury is. So a 1-hour meeting with me, of course, I can do as a juvenile defense attorney everything I can to educate and inform a child. But when they leave my office, I don't know if that's sticking with them, right? So if their parents are involved and helping them make decisions, they can re-explain, reinforce that process. Of course, children in need of care might not have a parent or a guardian to support them. I always give my youth the option to bring a parent or guardian into our client meetings if they choose to do so. And naturally, SYNC children might not have anyone that they want to invite into that initial meeting, and that is just a lack of support overall. These are just some statistics that are semi-related to that discussion of parental figures and the effects on children in need of care. What I found particularly interesting was this fourth point. So there basically data shows that if a youth in Kansas is in detention and can be released to their parents, courts often do so. So at that detention stage, like I said, if a parent is there ready and willing to take their child back into their home, that puts them at a significant disadvantage compared to a foster youth who may not have anybody there advocating for them to return home. This is more, it's not entirely related, but this fact just fascinated me. I came across it yesterday. So of course, all kids in the system, they have the standard constitutional rights that adults have to not self-incriminate, to remain silent, and to request an attorney. Interestingly, only 2 states out of 50 mandate that attorneys be provided to kids during police interrogation. Kansas is not one of those. Now, of course, if a child says, I want an attorney, I'm not speaking to you, then they are entitled to that counsel. But these 2 states that provide counsel are essentially ensuring that kids have that attorney before they're even questioned. And that does not happen in Kansas. Lack of stable housing, a lot of this is going to overlap. So how does lack of stable housing, often faced by SYNC youth, how does that affect their outcomes in the juvenile justice system? So again, here's our little 5-step process of juvenile offenses. When it comes to stable housing, I just picked things that I see in practice. I think that you could identify plenty more. I could have probably come up with plenty more. But when we see lack of stable housing, a lot of the times, again, we see that affecting children in need of care disproportionately compared to children who are at home and not part of the SYNC process. So when we have a detention hearing, one of the first questions is, does the offender have a place to go? Again, if a parent is there saying, we have a house, we can provide oversight, this child has a home, please release them, that's a lot more compelling to a judge than a child who is in the foster system and perhaps whatever crime they're being accused of has gotten them kicked out of their former placement. And now a judge is saying, hey, where is this child going to go? DCF might not have an answer. And that unfortunately can affect whether a child gets out of detention. Then when we look at detention and releasing children, where they're released can really have an impact on whether they follow the rules. So conditions of release is kind of a fancy way of saying bond conditions in the adult world. So when an adult's released from jail and awaiting trial or a plea, there might be certain steps they have to take, like avoid co-defendants, you can't talk to them, participate in UAs, so that would be like drug testing, meet with a probation officer. So a lot of the times we ask, is the juvenile's placement going to help them succeed in following those, or is it going to hurt them? Then, of course, what risk factors exist in the juvenile's post-release placement kind of goes along with that. And I'm mostly bringing this up because the more oversight, the more parental oversight that a child has, probably the more likely they are going to succeed compared to children that do not have that parental figure, that stable housing. Then at sentencing, housing becomes important in many of the same ways, but of course, a judge is again going to look at where is this child going to go, and are they being released to a place that can help them succeed? So again, when we have those youth that have parents showing up and saying, "Don't worry, judge, we'll take care of it. We'll make sure that Bobby gets to appointments. We'll make sure that he doesn't mess with his GPS monitor." That's significantly different than a judge looking out into the courtroom and there's no parent saying, "I will help this child." And oftentimes in those SINC cases, children, of course, have their social workers, they might have their foster parents, but as you can imagine, it's not the same stability that you would see for a child returning back to their home. These are some statistics related to housing and children in the system. So, of course, I think we could all probably guess as providers in this field, housing instability increases families' risks of entering the child welfare system. What I found particularly interesting is, so group homes is one option for foster youth, for children removed from their home. Oftentimes we see children placed in group homes who have struggled to be successful in a foster placement, or for one reason or another, they are, quote, less desirable for a traditional foster home placement. So like children who cannot be around younger children, children who have extreme behavioral or psychological issues. A lot of the times they end up in group homes rather than foster placement. So as we talk about housing, I found it relatively disturbing and interesting that this fact that children placed in group homes are much more likely to become involved in the justice system than children placed in actual traditional foster homes. So when that judge is deciding what do we do, the judge is going to be weighing whether they mean to or not. If I release this child back into a foster home, that might make them more conducive to being successful than releasing them into a group home, if that makes sense. This last statistic on this page isn't entirely related to what we're talking about with SINC and the juvenile justice system, but I did find it just very compelling. So in children in need of care, when we look at those children within 2 years of turning 18, if that child has been in 5 or more foster placements and or group homes in their time in foster care, then they're 70% more likely to become involved with that criminal justice system. So, of course, a lot of children could bounce around to many homes when they're in the child welfare system, or a lot of them can be lucky enough that they, find one foster family and they either get adopted or then they're reintegrated back with their parents. So that statistic just shows the importance of housing and stability. Limited financial resources. So again, kind of obvious to us in this field, but children in need of care have limited financial resources compared to some other youth. Again, these factors can equally apply to children who are not in the child welfare system, who may be living with their parents but living in poverty. So this can affect children in a variety of ways, but for the most part, our SINC children are not running around with access to money, to resources, that kind of thing. So here's our chart. Again, I didn't even bother to put bullet points on this one because there's just so many that we can talk about. So when we talk about limited financial resources in the juvenile justice system, there is so much impact on children. And again, children in poverty experience this as well as children in the welfare system. But we talked about earlier, of course, children have the right to have counsel before they're questioned by police. Well, if Kansas doesn't have a process by which to appoint counsel before interrogation, what is a child in need of care supposed to do? What is a child struggling with poverty supposed to do? When we look at children that have resources, wealth, assets, their parents might have the education and the wherewithal to stop an interrogation, to hire them counsel. I'm sure we all know a few people out there that have kind of their family attorney on speed dial that they can call. So getting that attorney presence early on in the case is so vital, and a child in the welfare system is never going to have that unless they have the wherewithal to specifically ask at the very beginning of a police interview. Then I like to talk about just attorneys in general and access to attorneys. So financial resources impact what kind of lawyer you get. And not only that, it impacts what kind of contact you have with that lawyer. So as a public defender myself, I am not at all dissing on public defenders or saying that they're not great lawyers. I think that many of us public defenders do a better job than many private attorneys. But in reality, we have to take into account that public defenders in Kansas and many other states, we are generally overworked, underpaid, high caseloads. So you could have all the knowledge in the world for defending a child in need of care in a juvenile defense case, but if you have 100 other youth that you're trying to represent at the same time, obviously the time that you can spend on any individual case is limited. So children can be at a disadvantage when they have that public defender versus hiring a private attorney and a private attorney, they get to kind of pick their caseload. They decide, is this a case that I can take? Then they also usually have more access to like paralegals, support staff, etc. So again, that kind of comes down to attorney like time. We'll get to a statistic in a second that talks about the importance of children having access to counsel throughout the entire process and the importance of children being able to easily contact their attorney. And again, if you have an overworked public defender with 100 cases to deal with, it's just naturally results in they might not be able to return that youth's call as quickly. They might not be able to meet with this child on a monthly basis, and perhaps a private attorney can. Then when we move to things like sentencing, so we talked about earlier, sentencing can involve the court ordering the child to pay restitution. Restitution is just a fancy way of saying paying back the victim for any money damages or loss. The court could order that the child pay for like court fees, or the judge could order that the child pay some fines. So, for example, I've seen some kids ordered to pay or reimburse the Kansas Bureau of Investigation for the DNA testing that was done in their case. Naturally, finances really play into your ability to complete your sentence and be successful. So children in need of care typically have no access to financial resources unless they are able to work and have access to that job. And of course, a lot of our non-SANC youth have parents who are willing to step in, help them pay fines and fees, and ultimately complete that sentencing term. That really comes into play in a big way when we talk about expungement, getting that juvenile charge off someone's record. So in general, I won't get into it, but in general, expungements require that that all fines, fees, and court costs have been paid. So children in the system could be starting with that disadvantage and not be able to get an expungement due to fines and fees and not having the money. So these are just some statistics. This talks about the frequency of contacts with your juvenile defense counsel, early and continuously help that child in ultimately being successful in their case. Children, I think, generally are very suspicious of adults, especially when they're in the child welfare system. So you can't just jump in and be rock star attorney and magically help your juvenile. They have to be able to trust you and talk to you. And then this last bullet talks about how fines and fees associated with these juvenile sentences can follow a child for years. So maybe they complete probation in 1 year, but if they're ordered to pay $2,000 in restitution, that could be hanging over their head for years to come. Again, much more prevalent in the child welfare system. Then this fourth factor is increased agency oversight, kind of more eyes watching, think of it like Big Brother. So children in need of care just generally have more eyes on them and more eyes who are either required or willing to report issues. So I don't have any nice statistics on this. This is more anecdotal and logical, but of course, when we see our kids in the child welfare system, they're working with social workers, maybe therapists, foster parents that they're staying with. Often the professionals that run into children in the child welfare system have a duty to report crimes as well as suspicions of criminal behavior. So then, just think of a child in their home. We often see children who, commit a little battery on their sibling, right? So I've thrown a TV remote, I'm sure, at my sister. She's fake punched me, that kind of a thing. Our parents did not call the police. They just chalk it up to sibling rivalry. This is kids being kids. In a foster home, if a battery occurs, if one foster child hits their parent, slaps their sibling, throws something, or damages property, they're likely going to be reported to the police or the foster care agency. So these things that typically we see outside of the child welfare system that are dealt with within the family, that's not the case with foster children and youth. Many people or many children in foster care, especially, they interact with more social workers and more professionals than non-SANC kids. So the child is expected to trust these adults they're working with because they don't have that parent, they don't have that guidance. Yet these people that they're talking to don't owe any confidentiality to them. So not like parents do either, but I think many times, just logically, if a child entrusts a parent with some information that could be deemed as criminal, tells their parent that they shoplifted, that can be dealt with, in the family, that can be dealt with outside of the justice system. that just doesn't happen with these SANC kids. So just kind of to wrap up, again, a little bit of a disjointed presentation. I am an attorney doing child in need of care work, representing children and parents, but I also do juvenile offender work. So these are probably my favorite topics in the law, one of my favorite things to talk about. And it's really a great pleasure to work with these kids, despite the trauma that they've gone through and the challenges that they face. So I just wanted to kind of give a little bit of a blurb for what can others do to help. So I kind of geared this towards not only lawyers, but other service providers. So what are some of the things that service providers can do to help vulnerable youth in the child welfare system, vulnerable youth facing juvenile justice issues? Because I'm a lawyer, let me start by saying I'm not giving legal advice. So this is just some tips and tricks, some things that I have used. And of course, depending on who's watching, these may or may not apply to you. One thing that you can do as a service provider, whether you're a lawyer or not, is be aware of the rights that juveniles are entitled to. I believe, I don't have it in front of me, but when I was researching for this presentation, I came across a survey that was done in Kansas across basically child welfare stakeholders in the state. And the majority of them were not able to accurately describe that a child is entitled to an attorney at the first initial police contact or interrogation. A little bit shocking, just because the frequency at which social workers interact with children, take them to the police station, that's kind of an important thing to know. The second thing that service providers can do is just be aware that these disparities exist. So be aware of the fact that children in need of care face an uphill battle in the juvenile justice system. They don't have access to the resources, to the support that necessarily other children do. And really don't be hesitant to point this out. So just as a lawyer, when I'm practicing, oftentimes in the appropriate context, I will make the fact that a child is in the child welfare system, I will make that as an argument to the judge, like, hey, judge, this child should not be incarcerated solely because there's not a parent in this courtroom willing to take them back. They have every right to be released just like any other child does, and it is not their fault that a parent is not here. Third, assist juveniles in understanding their basic rights in Kansas. Obviously, only to the extent that you know those rights and know how to inform the child. So many youths that I talk to, many of my clients, not just my children in the child welfare system, but also my juvenile offender clients, many of them, when they talk to me, it's the first time that they've ever heard that they can choose not to consent to a search by police. They can choose not to speak to police. So just giving children the tools for what to do and what they are and aren't allowed to do can be very helpful. Along those lines, kind of explaining to juveniles any misconceptions that they have. So again, along with the police search line, I have heard so many teenagers tell me, well, I said yes to the police searching my car because I thought you had to. And so naturally, just helping children understand their rights can go great lengths in helping them in that system. Then this is more of probably an attorney tip, but of course, other service providers could do this as well. Role playing different scenarios with juveniles. I have found to be endlessly helpful. So I think that I could sit with a child, with my client, for an hour and tell them, if a cop pulls you over, what do you do? If police has to talk to you, what do you do? And I can just tell them what to do. But in reality, um, I don't know that they're really absorbing that information. So one of my favorite things to do is advise my juveniles about their rights and tell them their options. And then at the end of our appointment, um, every time I see them, every time I talk to them, I typically like to stop my my juvenile clients and say, "Hey, I'm a police officer. I'm coming to you telling you I'm suspicious of a crime in the area and I want to talk to you. What do you do?" And I make my juvenile clients practice saying, "Hey, I have a lawyer. I am going to remain silent until I have an attorney." Um, my my juvenile clients hate that for the most part. Some of them like it, but most of the time they kind of roll their eyes. But um, I always say, before you leave this meeting, before we end this call, I'm going to ask you a question and we're going to practice. Because of course, just being able to repeat that line over and over again, just being able to say, "Hey, I'm going to be respectful to this officer, but I'm going to invoke my rights," that really helps children succeed in the long run. And sometimes that's the most that I can do as an attorney, is just to educate them. So that's the extent of my presentation. Again, I could have gone on for hours. I have plenty more facts and statistics that I ran into that I wanted to include, but that is what I have for today.
We do have a question in the chat. Does KLS handle CINC juvenile foster care, kinship care, or adoption cases?
In general, yes. So to the extent that KLS handles child in need of care cases, that's going to depend on the office. So in the Topeka office, we have a contract with the Douglas County court to do child in need of care cases. Same with in Douglas County, we have a contract to do juvenile offender cases. Other KLS offices across the state have similar contracts, but not every office. And then when it comes to kinship care, what that's referring to is essentially when there's not an available parent, getting a child with a guardian to prevent them from entering a sync case. That we do have statewide programs to help relatives, to help family friends gain guardianship or custody of children in order to avoid that child welfare system.
Hey, Brent, I have a couple of questions. This is Carolyn Moore. Okay, first of all, does CASA ever get involved with these kids?
Yes, so CASA, of course, so CASA stands for Court Appointed Special Advocate, for those that don't know. CASA workers are typically a supplemental advocate that is appointed to a court, to a child in a child in need of care case. So basically, the child has their social worker through DCF, and then they have this court-appointed special advocate who is a volunteer who looks out for the child. Typically, their caseload is a lot smaller, so they can really focus on these kids. CASAs can be very, very helpful in terms of helping children understand the system. In other ways, though, it can be harmful in a sense too, because of course, court-appointed special advocates, if a child reveals something to them, they can put it in their report. They will often tell DCF. So it can be very, very helpful, but also there are some downsides. So typically when I have a child who has a sync case and a juvenile case, and there's a CASA worker, my job as their attorney is, of course, to caution them, like, don't tell anyone anything like criminal, don't implicate yourself to anyone who does not owe you this duty of confidentiality.
Okay, and then my next question is, you hear about juveniles' records being sealed, so that doesn't follow them around, but that's not the case if they still have fines they haven't paid. It doesn't get sealed?
So I think probably what you're referring to is like expungement. So obviously, when we talk about cases being sealed, that has to do with, does the public have access? So in a SINC case, it's no, there is no public access. In a juvenile offender case, there is, but it's more limited. Now the court
Right.
could, under certain circumstances, seal a case. So for a particularly vulnerable child, a court could say, I'm sealing this case, it's not open to the public. When it comes to expungement, and this goes for adults and children, one of the prongs, the requirement to expunge or delete that criminal record from your history, is that you have to be paid up on fines and fees. So, of course, that affects adults and children facing poverty. But what we see in many juvenile cases is if mom and dad are willing to step in and pay those fines and fees, they're going to be eligible a lot sooner than a child who maybe ages out of the foster system.
Okay. Thank you.
I saw one of the questions on here. So do you find there's a better impact for juveniles when sentencing is sent back to the SINC home county? So what this person is talking about is in the juvenile justice system in Kansas, if a child, let's say, has a SINC case in Douglas County, but they commit a crime in Shawnee County, the juvenile justice statute tells us that the crime, the adjudication, the guilty, not guilty determination will happen in Shawnee County, so where that crime took place. But the law also says that when a child in need of care case is involved, that criminal case for sentencing automatically goes back to the home county where the child in need of care case is. So a child in need of care case in Douglas County, if a child has 10 different crimes in other counties, they're going to get taken care of and then sent back to Douglas County for sentencing. That can be a big positive or a big negative, depending on the situation. So in Douglas County, historically, we're more about rehabilitation and not incarceration. I won't name specific counties, but there are many, many out there who are more interested in incarceration. So I have many SINC kids that come to me just for sentencing, and I feel very lucky for them. And I tell them, you are very lucky that this came back to Douglas County as opposed to going, to another county for sentencing. The downside could, of course, be if you're seeing the same judge for sentencing time after time, that naturally goes into some issues. So biases by the judge, they might know more about you. And again, that can be positive, negative.
Who do we talk to about getting the rule changed that minors don't have the right to legal representation? Like, how do you get that changed? Because that just seems like a no-brainer that you have this minor, they don't know, their brain's still forming, they can't think through consequences for their action, and we're not giving them representation. That is the dumbest thing I've ever heard of.
Yeah, and of course, so they are entitled to it. It's just at what process do they get it? So, like we talked about, usually in Kansas, the first time you get a court-appointed attorney is when you've been charged, you appear in court. That doesn't cover that pre-investigatory process. And now in Kansas, there is a statute that says basically if a child is under 14, they cannot be interrogated by police, without a parent or guardian. That doesn't make me feel much better because that means 14 and up. Police don't even have to tell a parent or a guardian that they're interrogating that child. So, I mean, to really make systemic changes there, that would be talking to legislators and advocating for legal changes.
I don't know if you have time for one more question in the chat since we're over time.
Yes. Okay, so this person is asking about aging out. So supports and services. So again, some children turn 18 while they're still in the child welfare system, and we refer to that as aging out. The supports available are going to vary from county to county. So DCF, oftentimes when a child ages out, they're assigned a DCF caseworker into adulthood to help them navigate the DCF benefits they're entitled to, and things like that. But again, kind of depends how adept that worker is at figuring that out. Other than just local resources and what might happen, I'm not aware of anything statewide that is there to help children moving forward. A lot of it is what resources do they have available, and is the child asking the questions they need to?
Well, thank you so much, Bryn. Really appreciated this presentation. It was super helpful. This will be recorded. It is recorded and it'll be up on our website in the next day or two. So if you jumped on late and you missed anything, you can check out our website and rewatch.
And don't hesitate, anyone, to email me. Again, I love to have these conversations, and I'm sure that my presentation left a lot of things unsaid and potentially muddied the waters a bit. So always feel free to reach out to me by email. I'd be happy to chat.
All right. Thanks. I'll have a good rest of your day.